Hey, what's up, guys? This is Rich Klein from the Diamond Law Group. Today, we're going to be covering title insurance and reviewing title reports. Before we begin, just wanted to go over what title insurance really is. You can see our definition here. In reality, though, title insurance says that once you purchase the property, you're going to be able to sell that property sometime in the future. There's two types of title insurance. First is the lender's policy. If you're taking out a loan on or a mortgage on your new purchase, or if you're refinancing, you're going to need a lender's policy that insures the lender's interests. And then if you are purchasing the property, you're going to want title insurance versus the seller's. Moving down here, just to show you how title insurance is calculated, if you are purchasing and taking out a loan, the policy for the loan is 30% of what the actual full title insurance policy is. Sometimes I have clients say that they don't want to pay for title insurance because on their loan estimate from their lender, it says that title insurance is optional. That is 100% true. Title insurance is optional in the state of New York. However, I would personally, as the buyer's attorney, never allow my client to proceed without title insurance. Reason being, there's just too many things that can go wrong in the future for them not to do so. And, you know, it's the larger of the expenses, the owner's policy for the buyer, and they think that if they get rid of that, that they'll be saving the full fee. But in reality, if they're also taking out a loan, that mortgage policy then goes up to 100% of what it should be. So in reality, they're not really saving all too much compared to what the potential issues could cost in the future. So in order to find out how much title insurance is, you can go to the Department of Financial Services. Here's the website address up here. Then you can scroll down to TIRSA, which is short for the Title Insurance Rate Service Association. At the bottom over here, they have a rate manual that you can download. And we are in what's known as Zone 2. So you could just search this document for Zone 2. Nassau County, Suffolk County. And here is our rate for insurance. So the first $35,000 is a base fee of $382 for the owners, and the loan is a little bit less. Then for every $1,000 thereafter, they charge a certain dollar amount on a sliding scale. All right. So this really doesn't tell you what the totals would be for the average cost of a home on Long Island. So we'll do that next. But this is just to show you how it is calculated. So we're going to go back to a different website through Stewart Title Insurance. This is one of the major underwriters in this area. You're going to put in your county as Nassau County, one family dwelling. This is for a purchase. Again, here's our website that you can find this all out. And then you click calculate here. We're going to put our average purchase price in Nassau County as of March of 2022 is $650. We're going to presume that our buyer / borrower is putting down 20%. So they're taking out an 80% mortgage. And then we're going to calculate everything. So as we can see here, the title insurance premium, this is what it would cost the average buyer in New York, in Nassau County. And this is what the mortgage policy would be. As you can see, that's reduced from what the actual owner's policy would be. While we're on the topic, just to show you guys, this is what the mortgage tax would be. It's 0.8 of 1%, less $30. And then the lender has to pay what's known as a quarter point, 0.25% of the loan amount. That's what the lender would pay. And then one of the other statutory fees that we have here in Nassau County, New York State, is the seller has to pay a transfer tax. It says the rate is 0.004. In reality, if you just take the purchase price and divide by 250, that's what the Nassau County or Suffolk County transfer tax would be. There's other municipalities such as the Hamptons or New York City that have their own fees. We're going to have another course coming up about closing costs where we'll dive into that a little bit more in depth. All right, but for our purposes now, when we talk about title insurance and what it is, this is what your buyer is going to have to pay in order to insure the transaction and in order to ensure their lender's protected as well. All right. So when you first receive your title report, the first thing that you're going to receive is your table of contents, if you will. And the beginning part that we're going to cover today is about the Schedule A. You might have heard that terminology, the Schedule A certification page. This is what it looks like. You're going to have a title number up here. That's how you're going to reference the transaction. The effective date. What the effective date is that the municipal records are a little bit behind. And this date here is as of when the title report is reflecting the latest searches within the municipality. After you go through such things as COVID, you can imagine that the effective date may not be as recent as it normally would be. The property address goes here, the county and town, the tax ID. This is also known as the section, block, and lot, or the legal description. This is what you would identify the parcel or parcels as. This is how the new buyers would have their names reflected right here. All right, and that would match the incoming deed as well as the mortgage and other loan documentation. Here's where the bank would go. All right, and then this is the type of interest that they're receiving in the property, and the vast majority of the time it's fee simple. That's of course for another day about how people could take title to the property. And this is when the homeowner, the existing seller, took title to the property. This is where the seller's information would go here and how they're currently vested. And this would state the previous information as to when they took title, whatever that deed was. And again, this is known as the Schedule A over here. Moving back to our table of contents, they would then have the meets and bounds description of the premises. That's where you would have the legal description. And that's something we're going to cover when we talk about COs and surveys in our next course that'll be released on June 1st of 2022. So we'll cover more meets and bounds description of the property. That's where you have the legal description. Next, you have what's known as the Schedule B. This is where you're going to find all the issues. So when I, as the buyer's attorney or the seller's attorney, am reviewing the title report, this is what I go to, the Schedule B. So in the Schedule B, it notates anything that the attorneys, specifically the seller's attorney, should be paying attention to in order to clear title. First thing is any tax liens have to be paid up at closing. Any mortgages that are open of record. It's tricky to say mortgages. Sometimes you should just say loans because that includes such things as home equity lines of credits. It's also subject to any rights of tenants in the property because they have different rights that are not taken into consideration when you're purchasing the property. In other words, you can purchase the property subject to any existing tenancies. Next is the survey, subject to anything that an accurate survey would dictate. We're going to go over that, like I said before, in our June 1st class. Covering some restrictions are such things as utility easements and things of that nature that are coming with the property. You can't really do too much to get rid of them. This is a new item for online notarization that's pretty strict nowadays. It needs to follow specific rules. Next is anything having to do with violations to the effect that you can actually use the property and it's not a lien against the property. If it's a lien against the property, then the seller needs to take care of that. The following categories next when you're reviewing the title report are difficult transactions, if you will. So for instance, REO or real estate owned properties, you're purchasing from a foreclosing lender, there would be additional language here. If it's a short sale, if it's a foreclosure, you need senior underwriting approval for those types of transactions, all right? At the closing, they also need everyone's driver's licenses or passports. It really should match the names of the seller. We'll go over that in just a minute. And at the closing, any affidavits that are required will be signed. And usually they'll accept certified bank attorney or attorney escrow checks. You cannot use personal checks at the time of closing. You scroll down a little bit, it says that if there's any documentation that's discriminatory, that's deemed to be illegal and unenforceable. So unfortunately, sometimes you see that with some covenants and restrictions. That's obviously not acceptable, and it doesn't pass through with title today, thankfully. The municipal searches are what they refer to as FYI, and that's something, again, we'll discuss on June 1st, because surveys and COs are going to take up at least 1 hour of another continuing education course. Power of attorney, if one's going to be used, they need to review it. For the most part, everything's in black ink, and if it needs to also be legible. All right, so that's the Schedule B. That's very generally what it covers. There are a whole slew of other items which we'll get to after we get past the table of contents. But next, it would show the municipal searches. Again, they write that it's FYI. They're just doing it as a courtesy for the real estate attorneys, so that way they don't have to go down to the building department. This is what your municipal search would look like. They have the tax search here. You would have your certificate of occupancy, housing and building violation search, street report, and other municipal searches, so that way we can see if there's any issues regarding the property itself. And then they would attach the last deed of record and exhibits for any items that you also would need to review, as well as any affidavits. So that's really it regarding the actual title report itself. What we're going to cover now are some other items that you're going to see within the title search, and that would be more broken down if that was an actual title report that we were going over. So the first thing is, if the seller was in foreclosure, there would be something known as a lis pendens, and the lis pendens is literally Latin for that there's a pending litigation against the property, and the title company of record, obviously, who's literally in the business of ensuring the transaction is not going to be subject to any future litigation, would have a problem with that. The seller's attorney would need to obtain a foreclosure payoff. It is not the normal payoff that you would just be able to have your non-defaulting borrower call up for. It needs to be specifically from a foreclosure attorney, and they need to put specific language in the foreclosure payoff stating that the lis pendens, or the LP as they're abbreviated, is going to be released after they receive their money. So that's one of the common things that you might see in a somebody who's in default with their existing mortgage. Next, one of the most common exceptions in title that you will see is something known as a prior owner exception. And what that means is that the existing owner purchased from somebody else previously. It's that previous homeowner that has an issue. Such things as satisfied mortgages that are still open of record. And what I mean by that is, let's say we're buying from person B, who purchased from person A. At the time when person A sold their home, they had a mortgage to pay off. And we went to closing on that transaction. And the title closer at that time sent in the money for the payoff, and the bank of record at that time then sent what's known as a satisfactional mortgage to the municipality. And they send in a check in order to record that document. The problem is, when you come to Nassau and Suffolk County, everything is way more expensive than it is in the rest of the country. For instance, in these two counties, it could be upwards of $1,000 to record one single mortgage satisfaction. The problem is, the title company, at the time when they closed the transaction, saw that the bank was in charge of filing the satisfaction. And when the bank of record sends in the satisfaction, they only send a check for maybe 50, 75 bucks. The people here in Nassau County see this, they understand it's too little to record the document, and they kick it back to the bank, who then literally does absolutely nothing with it, because they usually don't have to, they don't go after the previous homeowner to collect any money. They don't really understand that it costs too much money here. And that literally will be an open mortgage on title forever. And there's nothing the existing person can do that we're buying from, because they have no privity, they have no information from the previous person that they purchased from potentially many years ago. However, how do we get rid of this exception? Well, at that time, the person we're purchasing from, the homeowner, would have purchased title insurance. They just need to literally take that title insurance policy and then send it to our existing title insurance company. There's only maybe 4 to 5 major underwriters who insure these types of transactions, and they have a mutual indemnity with one another because they presume if one title company, one of their fellow companies, did all the proper research back then, that they're comfortable with that. And the existing owner's policy, as they refer to it as the title insurance policy, if you send that to the new company, that's all they need to do to clear up the issue for the current sale to our client buyer, okay? So all you need for any prior owner exception is the existing title insurance policy from the seller. And you say to me, Rich, well, what happens if our client, the homeowner, doesn't have the homeowner's insurance, the title insurance policy, sorry, what do they need to do for that? Well, on the back of the deed of record, which is public record, there will be a title insurance number listed, potentially through an abstract company who was kind of the title insurance broker, if you will, for that particular transaction. The insurance companies nowadays can look through their system and see which abstract company insured the transaction at that time and request a mutual indemnity agreement from them. If they are no longer in business, we might be able to ask some of the other title insurance companies, the underwriters, if you will, if they could somehow figure out if they underwrote the transaction by searching for the property address as well. And that's the most common way to clear up the issue. Like I said before, it happens very often, specifically regarding the mortgages. Next is something known as a no consideration exception. And what happens for that is, let's just say a woman owns her home, then she gets married and she wants to put the home into her name and her new husband's name. She then does this, they record the deed and they think everything's fine. What's the problem? In order to have a real estate transaction move forward and receive the proper indemnifications, you need to pay what's known as consideration. And for consideration need to be paid, if you just sold the property, in other words, the wife in my example sold 50% of her property to her now husband for free. She didn't pay anything for it. There was no money that changed hands. And now they're going to sell this property, and the title company wants to make sure that everyone's on board with this transaction. So they would then have the husband and wife sign a no consideration affidavit that they sold the property. The wife sold 50% of her property to the husband. So now they both own it and they both agree to that. That's the easy explanation. The problematic explanation is the exact opposite. It's where you have husband and wife who then take one another off, potentially through some type of marital issue, such as a divorce. And now we just represent the wife who's selling the home. The problem is, for all intents purposes, you have the chain of title going from the husband and wife just to the wife, but there was no money that exchanged as far as the title company is concerned, because they can reverse engineer that by figuring out that there was no transfer tax paid at that time. And they now want the husband to sign an affidavit that he transferred his interest in the property to the wife for what they deem to be no consideration. There's a couple of ways to get around it. If there was a divorce decree and there was some type of other agreement, such as alimony or child support, that usually will suffice to show that there's been consideration paid. Sometimes, people want to add on or take off people that they don't have a relationship anymore. It becomes very problematic to make sure that this goes through. Just taking yourself off of a deed doesn't necessarily mean that you're no longer obligated to pay your mortgage. So for instance, if you have two people who purchase a home together and they're both on what they refer to as a promissory note, and they're both on the mortgage, and then they take one person off for this, that, or the other reason, and then the person who remains pays the mortgage back every month, they're still on the hook for that mortgage. And you would need to explain and get an affidavit from the person who's no longer on title why they came off and why they received no money, because the title company is literally ensuring that this person's not going to come back and make a claim that they were entitled to some of the sale proceeds. That's what we're trying to accomplish here. All right. Next is, if the seller has a corporation, even if it's a brand new corporation, you have to send every single type of documentation showing that. It's a filing receipt. You have to make sure that your biannual taxes are paid. You have to have a corporate resolution authorizing whoever's attending the closing to sign on behalf of the corporation. You need to have an operating agreement to state who's actually authorized to sign these documents. You need to have a properly formed EIN, things of that nature. So there's a lot of seller exceptions, just to make sure that the person claiming to have an ownership in the corporation actually has the ability to sell that property. Next is having to do with exceptions regarding the seller's mortgage payoff. We would obtain a recent statement and their social security number in order of payoff. That would also reflect any tax arrears or escrow impounds that are still open of record. And we would calculate how much to pay off that loan. It's a very common misconception amongst sellers who have forgotten that when you close on your property, the payoff is always different from what it is that homeowners think that they owe. That's because when you go online, all that you see is the outstanding principal balance. So today happens to be April 18th, 2022. I log into my Chase account and I see that I owe this amount of money. But then I schedule a payoff, which should be a couple of days after your closing, so as to allow the overnight funds. Usually it's done in that fashion. Sometimes you could wire it, but most people prefer to send a check to make sure that it hits the right spot and they sign for it, etc. You always make the payoff a couple of days after the closing date, just to make sure that it processes in a timely fashion. That being said, if today is April 18th and I made my last mortgage payment, which would have presumably been April 1st, that was actually for March's interest. So what the title company would then do is add on interest on the payoff letter all the way through April 1st, through whenever we made the payoff date, which would be the closing date plus a couple of days thereafter. So it's usually about another month, depending on when you close, higher than what most clients think that they actually need to pay. The next topic is water readings. Okay, so in Nassau County, in Suffolk County, it's traditionally not all too much money, but water is one of the few utilities that actually stays with the property. So you're going to want to obtain a final meter reading to make sure that it doesn't, the buyer doesn't have the seller's previous usage. So municipalities, you actually cannot schedule the water meter reading until after the closing. So you would need some type of maybe escrow or undertaking in order to pay that off after the fact. If you're closing in the boroughs, it's a little bit more exorbitant than here on Long Island. And it does take a long time, even pre-COVID, in order for you to obtain a final water meter reading. So you're going to want to get started on that as soon as possible. In the boroughs, also, you would adjust for the buyer and seller based upon the last reading. On Long Island, you typically don't reimburse based upon a previous reading. All right. Okay. So next are vesting discrepancies. So unfortunately, people pass away is the worst case scenario. So the title reads that it's from Mr. and Mrs. whoever, and now it's just Mrs. whoever who's selling the property. Title company wants to make sure that that this woman actually is the only person who's capable of doing so. And it's also relevant to how they held title at the previous deed. So if they were married, the presumption is that it's tenants by the entirety. And when the husband, knock on wood, unfortunately passed away, the property then would automatically, by operation of law, with no probate and no taxation, revert back to the wife. And now we have the wife who's trying to sell the property. So what we would need to do is unfortunately ask the widow for a copy of her late husband's death certificate, which she may or may not have readily available. So you'd have to contact New York State Board of Health, a health department, in order to get a copy of that. And as you can imagine, they're a little bit inundated at this time because they handle all the COVID, regulations as well. So vesting discrepancies, another very common one is a couple were not married when they purchased the home, then subsequently were married, and the wife presumably does not have anything in her maiden name because she changed her name. And now it's many years later, and she shows up at the closing with her husband's name. And nobody has any idea that this woman is who she says she is, just because she shares the last name as her husband. So in that instance, we would need a copy of her marriage certificate, which is also something that most couples don't have readily available, especially if in the midst of moving. So you would again need to contact New York State for another copy of that license. These things take time. So if you could find the last deed of record, whenever you take a listing, it'll be very helpful in order to speed up the process of ironing out any minor title issues before they arise. Otherwise, it may be a small delay as we're trying to close. Next is open mortgages of record or open loans of record. So the seller in year one takes out a loan. Rates go down or they want to refinance and pull some money out of the property, some equity out of the property rather, as a cash out refinance. And they perform what's known as a CEMA. It's a consolidation extension modification agreement, which in essence saves them the mortgage tax on their new loan because they already previously paid the same mortgage tax. So New York State gives them a break, so to speak, if you will. So what happens is sometimes in the chain of the mortgages, it's not done correctly. The CEMA was not drafted correctly. And it shows that there's loan A that's open of record and loan B that's open of record. And we then need to speak with the existing lender in order to either correct that document, or if the first loan was paid off, let's say it wasn't a CEMA, it was actually paid off, but it's still open of record. When our homeowner took out the second loan, if the first loan was paid off of record, but it's still open as far as the title company and the municipality is concerned, then we would need to get a duplicate satisfaction mortgage by contacting the lender at that time. The problem is some of these lenders are no longer in existence because they either went out of business or got purchased by somebody else or became part of another bank. So there's various companies out there that specialize in obtaining that type of title clearance and satisfied open mortgages in case your homeowner doesn't want to take it upon themselves in order to do so. So to continue, one of the other title issues that you may see from time to time are actual judgments against the buyer or seller. Sometimes people fall on hard times, and whenever you sell a piece of property in the state of New York, even if it's not the property that you're actually living in, and it gets attached to every single property that you own. So that needs to be paid off at closing. Believe it or not, red light cameras are something else that's very common. Parking violations, you could just think that you could throw it out or ignore it, but they will catch up with you if you try to buy or sell a piece of property in the state of New York, and you have to pay that online, provide evidence of it. If judgments are too much for the seller to pay, you could always pay it off at closing. If you cannot obtain a payoff letter, the title companies will often agree to hold double the face value. So if it's $2,000 judgment, they'll agree to hold $4,000 at the time of closing. You provide a payoff letter to them, then they'll release the balance of the funds to you. Other very common exceptions that you'll see are, let's say, condo exceptions. So you could have a condominium which has additional requirements, something known as the waiver of the right of first refusal. And what that means is that the condo itself actually has the ability to purchase the home out from underneath the buyer should they so desire. It very rarely happens, but the condo itself, in their infinite wisdom, does have the right in order to purchase the property. And they have to waive that right in order for the title company to ensure the transaction. They also have to provide a common charges letter stating that the seller is not in default with their association dues. There's other types of searches versus the actual buyer and the seller. If there's a bankruptcy search to make sure that neither party is in bankruptcy. If so, that needs to be discharged and the proper papers filed. It's also something that was the Patriot search to make sure that the name is not on a common hit list for things such as terrorism or money laundering and things of that nature. And if there is, then they would just do additional research to make sure that they're not one and the same person. You also unfortunately have life estate issues. So for instance, somebody sold the home and reserved a life estate, usually let's say a grandparent, and even though they don't necessarily live in the home or they may no longer be with us, you need to get a death certificate or an explanation as to how this person was able to reserve a right in the property. Now it's being sold, they need to sign off on that, even though they don't technically own the property, they have an interest in the property. And whenever you have estate issues, you also have taxation problems potentially, and you have to have the estate with proper letters testamentary or letters of administration, depending if the unfortunate person who passed away had a will or not, or whether or not the will is being probated by the heirs at law. So whenever you get estate issues, you have to have the executor or executrix sign off on the estate tax for both New York State as well as the federal government, stating that there's no taxation due at that time. So the last thing I'll say is that most title issues are capable of being fixed. Proactively would be preferred rather than reactively. So the sooner we can order a title search, the quicker we can start working on everything. The boilerplate contract does state in paragraph 21 that the buyer's attorney rather can order a title search after they receive a commitment. So even though, most people want to work on it proactively, there are some attorneys out there that will still only order the title search after the buyer secured a mortgage. And in our previous video, we had said that it could take up to 30 to 45 days for the buyer to receive their commitment, and then another 3 to 4 weeks for the title report to be generated, depending on the municipality. So you're looking at 60 days into the transaction, which is obviously problematic if the parties are looking to close within 60 to 90 days. And then if there's an issue at that time, you could see why everyone's feathers get ruffled as to how this is just coming up now and why is there going to be a delay, and you have leases that are expiring or rates that are expiring and things of that nature. So most issues can be resolved. It would prefer to be worked on proactively. In my firm, we order it as the title search, that is, as soon as the buyer signs, to hopefully get a jump on that. The contract does say, though, that if the seller cannot convey clear title, the buyer could either proceed as is or cancel and receive the down payment back. No one wants that to happen. And in reality, the way I explain it to my clients, the buyers, is it doesn't really behoove the seller to cancel, because if they cancel with us, it's not like we're trying to be overly difficult. We're not trying to pinch them for some extra money from the transaction. It's that they literally can't sell this property to us. And if we proceeded, we then would inherit their issue, and it would be having the same complications when we go to sell. So it usually comes down to the certain circumstances between the parties as to the reasonableness of the delay and the likelihood of success, as well as the financial cost, in order to determine how the parties are going to proceed. However, when you receive a title report and your attorney contacts you and there's a long list of issues, the vast majority of them are very common and very easy to fix. There are some that are a little bit more complicated to address, but again, everything is capable of being fixed, as long as the parties are willing to do so. I always say, if there's a will, there's a way, and if there's no will, there's just no way. So it's on a case-by-case basis. If you have any specific questions that you want to run by us, we're certainly more than happy to assist you in any way that we can. We work with every title company that's out there. Some real estate brokerages have affiliations, which again, we're happy to work with every single one of them, and look forward to speaking with you guys soon. Hope you enjoyed this continuing education. Talk to you soon.